Good morning and welcome to today's webinar, The Essentials of Estate Planning and Elder Law, presented by Elville & Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville & Associates, and I'll be moderating today's event. So how this will work today, if you're new to our webinars, if you are, welcome. We're glad you're here, and if you're returning, welcome back. So you as the attendee are in listen-only mode. However, if and when you have questions, please note them in the questions panel on the right-hand portion of your screen, and we will take time throughout to address them. Your questions really help the presentation and add value. They help others learn, so please don't be shy in posing your questions at any time. You received the presentation on Friday by email for me to take notes on it if you wish. If for some reason you did not receive the presentation, it is available in the section marked Handouts in the panel on your screen to download at this time. As always, for CFPs, CPAs, and various other professionals on today's webinar, you may receive 1.5 continuing education hours for attending. For attendance records requirements on my end, please email me your ID number. And for CFPs only, I also must have the last 4 digits of your Social Security number as soon as possible so I can submit your CE hours for approval. Everyone will also receive a post-webinar feedback email right after the presentation, and we ask that you please just take a couple minutes to fill out the simple survey to offer us your feedback about the presentation. It's also an ideal time to request a consultation with Steve if you have any planning needs that your family and you may have at this time or in the future, and we always look forward to being a resource to you here at Elville & Associates. So right now I'd like to give you a little bit of background on our firm and share a bit about Steve. So you should be able to see my screen, hopefully. And actually, I got a little bit ahead of myself here. There we go. Elville & Associates, we were founded in 2010 by Managing Principal and Lead Attorney Stephen Elville. We have a number of different practice areas here at Elville & Associates, and they include estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning and asset protection. We have 7 attorneys, 12 staff members in 5 locations, and Steve and I are coming to you live from the Columbia Gateway Community location here in Columbia. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and the use of superior legal technical knowledge. We do offer a lot of education here at Elville & Associates, and we do that in a number of ways. We do that through our planning processes with our clients. We offer over 100 educational webinars and workshops in the communities we serve each year, and also by way of our accredited client care program. We're one of only 2 firms in the state of Maryland to have an accredited CCP, as we like to call it, accredited by the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion with every client, every time here at Elville & Associates. A little bit about Steve. Steve's work as an attorney for the past 20+ years has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. A member of many national membership organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. Also, last year's chair of the Elder Law and Disability Rights Section Council of the Maryland State Bar Association. He is a very seasoned speaker, if you haven't heard him speak, presenting at many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Also, I'm very pleased to announce this morning that Steve was named to the Maryland Super Lawyers list for a 7th time for 2022, so congratulations to Steve. And he also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization that he founded in 2014, and I'm privileged to be the executive director of. If you'd like to learn more about the Elville Center, please let me know, and I'll be happy to share our story and let you know how you can get involved. So with all that said, we're going to start the presentation. Before we do that, I'd like to share a brief poll with you to see what has brought you to today's webinar. And that actually is the question. What has brought you to today's webinar? And the choices are: 1, I am new to estate planning and need to get started. 2, I have a plan in place, but it is outdated and needs updating. 3, I feel my plan is on solid ground, but education is always great. Or lastly, 4, I'm an advisor here to learn to better serve my clients, which is always great too. So welcome to everybody, and just make the choice that best suits your situation so we get an idea of who we have joining us today. All right, we'll give it another 15 seconds or so here. Okay, the tabulations are slowly coming in. I'm going to go ahead and see what we have here so far. So we have 42% saying I am new to estate planning and need to get started, so welcome. We have 15% saying I have a plan in place but is outdated and needs updating. 22% say I feel my plan is on solid ground but education is great. And 19% say I'm an advisor here to learn to better serve my clients. So welcome one and all. Happy holidays to you. I love saying that. It's my favorite time of year. And Steve, I'm going to go ahead and share the presentation with you and make you the presenter.
Thank you, Jeff.
You should see that button pop up.
Here we go. Thank you. I see it. And I will go ahead now and just take over. Let's just double check.
Slideshow, start. There we go. Looks good.
All right. I thank you so much, Jeff. And good morning, everyone. Happy Monday to you and happy holidays to everyone. I'm sitting here in conference room 1 of our Columbia office of Elville and Associates, and I'm looking outside and I see it's a beautiful but very cold day. So it looks like everything is normal for the holidays. I hope everything is going well for you in your lives and that you're staying safe and well in these challenging times. And I would say continuing challenging times, but exciting times, hopefully, into the end of this year and into 2022. So thank you for being with us this morning. We're very excited to bring our fundamentals, our essentials of estate planning and elder law to you. We love to educate, we love to facilitate and expand the knowledge of our clients and potential clients and their families and their advisors. But we also want to give you a path forward to be able to take next steps. I know many of you on this call this morning are saying, by virtue of the poll, that you need to explore estate planning, you need to get the process started. So we want to show you the paths forward to actually do that in addition to our education. Many of you have existing estate plans and those need to be updated. And we're going to talk about updating and maintenance of estate plans. But again, we're going to talk about what is going on in the world today as the basics of estate planning and elder law as it continues to evolve in the world. But before I get started, again, I want to thank you for spending your valuable time here. I also want to thank Jeff Stauffer, my longtime friend and assistant, who is the executive director of our charity. But without Jeff and his stellar efforts, we wouldn't be able to put on this presentation or our webinar series of many, many events that we do throughout the year. So thank you, Jeff, for all that you do. And if you've never been on one of our workshop webinars, like this morning, you need to know that Jeff is an actual expert at doing this, an absolute expert is what I meant to say, and that he is very well adept at being able to take questions. He'll stop me at particular times throughout the presentation. So if you don't have the materials or you're having a technical difficulty or you just need to ask a question, just be sure that Jeff is looking and he'll be moderating as we go right along here. All right, so without further ado, I wish you all again happy holidays, and we're going to get into the next hour and 15 minutes or hour and a half or so of the essentials of estate planning and elder law. So what are we going to cover today? Well, we're going to talk about what an estate plan actually is and what the process is. Process is something that we believe in very much here at Elville and Associates, and we believe that an estate plan can do well or actually fail based on a good process or lack of a process. So process is very important. We're going to be talking about that. We're going to be talking about why estate plans actually can fail and what you can do to avoid that. So believe it or not, estate plans can actually go south. They can actually not work as they were intended to work. We want to definitely make sure we avoid that. We're going to be talking about wills versus trusts and understanding basically what that means. Probate, which is wills. Actually, you can have probate even without a will, or trust, which we're trying to avoid probate, and that is the probate versus non-probate conversation. Elder law taxation and asset protection, what's going on in those things today, as basically we have some peaks and valleys. We have some ups and downs in the legislative process and challenges throughout the COVID-19 era. What's happening in Congress, what's happening with taxation. We're going to be talking about all those things, plus elder law. Elder law is a very important aspect of planning. Many times elder law issues can arise on their own. For example, I was in a meeting this morning, a very serious issue about an elder law long-term care issue. But sometimes elder law can happen. The subject matter of disability and planning for disability and long-term care can happen even in a conventional situation. So how does that happen? How does elder law sometimes just pop up, and how do we deal with it? And as I mentioned, getting started, how to take the next steps. It's a lot that we do here to educate, but one of the most important things, especially in the COVID-19 era, is actually just getting started, understanding those next steps, and that's what we're going to talk about today. So let's talk about the estate planning process and understanding that. I emphasized the word process a few minutes ago. So we're going to talk about why plan. What are the various reasons, generally speaking, that people do planning? Wills, trusts, powers of attorney, advanced directives, and even advanced plans. And even for those people who do plan, why do many plans fail? Why do many plans fail to operate the way they should? So no matter what kind of planning we're doing, whether it's estate planning, elder law planning, special needs planning, tax planning, asset protection planning, we want you to have a goal. My experience has been that once clients can identify their goals, once a client can say, this is what I'm here for, this is what is important to me, then we can actually solve that problem. We can use the tools and the technical knowledge that are available today in today's world, and we can actually solve that problem. So we want to really encourage you to do something very fundamental, and that is really to understand what your goals are. And this is understanding what those goals are as you enter the process. Now, let's say you just intuitively know that you need planning, but you're not quite 100% sure what are the right questions I should be asking. What are the goals that I really should have in this process? It's possible through exploration and counseling that we can identify those goals. So if you don't really understand exactly 100% what your goals should be, this is something that we can explore. These are some basic things that drive planning for most people. Most people want to provide certainty for their loved ones, many people, or facilitate smooth administration. Some people have this goal. I just want to make sure things operate as smoothly as possible. Many people are driven by minimizing costs. I want to minimize the cost of administration. I've dealt with this before for a loved one. It was very expensive. I want to make sure it's as least costly as possible. Some people want to protect assets. This is a huge issue today, not only in the conventional sense of making sure we don't lose our assets, but some people want to provide for protection for spouses and children and other loved ones through planning. And then some people are driven for asset protection through long-term care counseling. In other words, there's a long-term care issue that's going to deplete a lot of assets. So we want to protect assets in that sense. So today I'm going to be describing 3 different types of asset protection so that we can completely talk about this particular issue. But this is a driver for some people. Many, many people are driven to eliminate or minimize taxes, so that won't be a surprise to you. But not everyone is the same. Most people have different aspirations or goals, so there could be a special reason why someone wants to do planning. So what we want to help you do is to really define what those goals are, what the motivations are, and help you identify that through the planning process. Now, some of you may be shocked if you haven't seen our webinars before to understand that we are very, very transparent about a particular issue that is a little bit negative, and I hate to bring that up, but that is the possibility of plans not actually working the way they're supposed to. Our whole goal here at Elville & Associates is to encourage clients to be intentional. We want you to have a process. We want you to be intentional. And why is that? Because we know that if you're intentional and you have a process, that the chances of your estate planning working the way you want it to work is extremely high. But we also know that if you don't have a plan or a process, and if you don't have a goal, we know that your plan can actually kind of fade away and not work properly over many years. So we want to be very, very transparent about this and understand that achieving excellence, achieving an estate plan that actually works, requires that you be intentional. Now, a traditional estate plan, which is something we're not going to talk about much today, a traditional estate plan has very little process, very little education, and very little interaction between the client and the attorney. But non-traditional planning, which is the kind of planning we want you to embrace, really does facilitate lots of education, lots of discussion, lots of goal setting, and that's what we want. We do not want a very, very limited traditional estate plan, which we're going to talk about a little bit in just a minute. So why am I emphasizing all of this right up front? Because many estate plans fail, and many times they fail just because there's not enough follow-up, there's not enough education. So I know you can't directly respond to me, but I want you to think about this question. Of all the people in the United States, let's say 100%, how many of those people actually do planning of some kind of estate planning? I'm going to give you about 10 seconds to think about that. Well, statistics tell us that only about 45% of people actually do planning. That means if we just take that simple statistic, that means that 55% do not plan. 55% of people in this country have no estate plan. And for people that are divorced or in different demographics like that, specific demographics, the number is up to 60 to 62%. So just think about that. The minority of people actually do planning. So of the minority, the 45%, here's my next question. Of those people who actually do planning, how many years go by from the time that person does an estate plan to the time they actually follow up and try to maintain that plan in some way? I'll give you another 10 seconds. Well, statistically, it's about 19 years at a time. So what we see right from the beginning is that if we don't have a process, if we don't have education, if we don't have some kind of a systematic way of the estate plan working through cooperation between the client and the attorney, or the continuing education of the family, what happens is estate plans tend to kind of get lethargic. And what happens is they don't get maintained for up to 20 years at a time. And that is for the people who are actually trying to do estate planning. So you see, we want to really focus on process and intentionality. We don't want an estate plan that actually becomes very lazy and in the end does not work. Is it possible for an estate plan to really kind of fall apart over a period of 20 years? And the answer is yes. If we don't maintain it, stay on top of it, make sure that our assets are aligned, make sure that we're updating our documents, make sure that we're keeping up with changes in the laws, we will have an estate plan that has a very high possibility of not working properly. All right, so thank you for sitting with me through that early set of setting the stage, I guess, for the rest of the presentation. So now I'm going to move a little bit quicker as we continue. We talked about traditional estate planning versus a process-driven estate plan, which I would call a more of a legacy process. Here at Elville and Associates, we call this our caring for clients model. But this won't be surprising now after the first few slides. A traditional estate plan is really an estate plan that focuses on documents. The documents themselves, if I were to hold up some documents here in my hands, that will, that trust, that power of attorney, those documents represent the estate plan as pieces of paper that get stuck in some drawer or they get stuck in some safe deposit box. That is when we are starting off on the wrong process, because we're looking at those documents as the estate plan. It is true that documents are important, but if we focus on them as the sole source of the estate plan, we are automatically going in the wrong direction, which we're going to talk about in just a second. Rather than that one-step process, we really want a three-step process. Now, we could create as many steps as we want, but for purposes of illustration, I'm just going to say, instead of just a really quick first process and a signing, meaning a one-step process like that traditional plan, we want to have a multi-step process. We want to design and implement the plan. We want to maintain the plan during our lifetime. And if we do those two things, then final administration, when we pass away, for our loved ones will be as least costly as possible, will be as smooth as possible, and as efficient as possible, which I know most people would want. So a process-driven educational estate planning process really incorporates more than just one phase. It focuses on education, it focuses on a life process, it focuses on maintenance and updating, and of course, this requires a two-way street. If you're motivated to do this kind of thing, you also have to have an estate planning firm that is willing to provide that kind of process. So it's a two-way street. Many of you may wonder, what is estate planning? What is the definition of estate planning? So we developed a very simple definition several years ago, and you can create one of your own, which I encourage you to do. I would encourage you, as part of your goals, to think about an estate planning definition. So here is something that I would just throw out to you if you want to write this down. Estate planning defined as really disposing or giving your property the way you want to the persons or organizations of your choice at the lowest possible what? Cost. So if you're writing this down, I would encourage you to think in terms of estate planning is about disposing or giving away my property in the way that I want to the persons or organizations that I want at the lowest possible cost. That is one definition of estate planning. All right, Jeff, I would say that's probably the opening 25% of the presentation. I'm just going to briefly stop to see if there are any questions at all. And if not, I'll just continue on.
No questions yet, Steve. You can keep on going on. Thank you.
Thank you very much, Jeff. All right, now that's the first phase. Now we're going to get into the will versus trust discussion. Now, if we ask Americans, what is the number one thing that you would like to understand or do with your estate plan? 97% of people, so to speak, will say, I want to avoid probate. But very few people really understand what probate is. So the next few slides, we're going to talk about wills versus trusts. Probate versus non-probate. So what is a will? A will is a testamentary document that basically sets forth four major things. What happens to my tangible personal property? Do I have any specific gifts or special provisions? 3, what happens to the balance of my estate? And 4, what would happen if no one is living? Where would my estate go? Those things are covered in wills and trusts, but just to keep it basic, that's what a will does. A will, by its very nature, is subject to probate. Probate is a process. Some of you on this call have been personal representatives or executors for loved ones, and you know what I'm talking about. Probate assets have to be processed through the public system. In Maryland, through the registers of wills, where an estate is opened, The estate has to go through, as you look down this list here, which is really just a mini summary of probate. An estate has to be opened, an inventory has to be filed, creditors have to be notified, an accounting has to be provided, all the beneficiaries have to be notified. If there are any taxes due, those have to be paid. Those things have to take place in the probate process. Now, what is the cost of probate? This is very much subject to speculation. It's also going to be subject to the persons who are involved. But by and large, we can safely say that the cost of probate, which includes all the fees of probate, the personal representatives commissions, attorneys' fees, CPA fees, and so forth, the cost of the Register of Wills fees, roughly are 4% to 7% across this country, according to AARP. So in Maryland, I would say it's more or less around 4%. These are the fees that are allowed by the court. Although this is not 100% accurate, this is roughly what the fees are, just for purposes of our illustration. So one issue is probate itself and what is the process of probate. Another issue are what assets are in probate. So let's step back for just a second. We have probate if we have a will, because a will by its very nature is subject to probate, but we can also have probate if we have no will. So let's say a person passes away and they have probate assets, or a person passes away with a will and they have probate assets. So what are probate assets? For those of you who are making notes, here is a simple definition of probate assets. These are assets that have no joint owner, okay? They have no beneficiary, and they are in the sole name of the person who passed away, the person we will call the decedent. So definition of probate assets, whether you have a will, whether the decedent had a will or not, they have no joint owner, no beneficiary, and they were in the sole name of the decedent. All right, so here is what a will-based structure looks like. So as we look at estate planning, a person who needs an estate plan or a basic estate plan would have a will, and that will is the driving force of the estate plan. But as you see here on the left and right, we have what we would call ancillary documents. We have powers of attorney, we have advanced medical directives. These are the documents that deal with incapacity, as we're going to see here in just a few slides. So the will is the driving force of what happens at death. The powers of attorney and advanced directives are what happens during life to avoid issues associated with incapacity. Now, quick question for you. Remember, we haven't talked about retirement assets, because why? Retirement assets like IRAs, 401ks, and so forth, those plans have what? Beneficiaries. Now, in the planning process, one of the most important things that we must do, especially in this day and time, where retirement asset accounts are much, much bigger than they've ever been. Many people are saving huge amounts of money in IRAs and 401ks and so forth. We have to make sure that we have a solid beneficiary, because as simple as that may sound, if we don't ensure that we have a beneficiary, then the entire house can come tumbling down, because the IRA or 401k had no beneficiary, and therefore all the taxes basically due at once. So we lose the possibility of deferring tax. But my point is that IRAs and 401ks properly done, meaning they have proper beneficiaries, are not part of the probate process. Those are non-probate assets. If they don't have a beneficiary, then they do become part of the probate process. So we want to avoid that. Now, a revocable living trust is simply an alternative to a will. Many people are on this call may have revocable trusts. Many of you may not be quite clear what is a revocable trust. So if you came to Elville and Associates or any competent lawyer and you said, I would like to get a basic estate plan, you would be basically presented with information about a will or an alternative to a will. So a will or a will substitute. A revocable trust is simply a will substitute. You'll notice as you go down this list of bullet points here, you'll see that a revocable trust does not help with asset protection, creditor protection. It doesn't provide any tax savings. That's because it's simply a private document that avoids probate. But remember, it does not avoid probate unless all the assets are properly aligned. Unless all the assets are properly structured, some of the assets are in the revocable trust, meaning a revocable trust has actually two steps. The first step is the creation of the revocable trust, which we'll talk about on the next slide here in just a second. And then the second step is making sure that the assets that a person owns are properly retitled in the revocable trust, with the exception that retirement plans cannot be retitled in the name of a trust and they stay outside the trust. Usually life insurance stays outside the trust, but all of the other non-retirement assets should be titled properly inside of the trust. Mutual funds, stocks and bonds, primary residence like real estate, money market accounts, savings accounts, and so forth, CDs, all of these types of assets, savings bonds, are all titled in the name of the revocable trust. So when we go through those two steps, and that's very important, we go through those two steps and we have a fully funded, fully aligned revocable trust. Now at the person's death, at the decedent's death, we have no probate. We have no probate on the assets that were outside the trust, like retirement plans and life insurance, and we have no probate on the inside assets, the assets that are held inside of the revocable trust. Now we have a successful revocable trust. Now you'll notice the cost here of a revocable trust is widely considered to be a little bit less than half of the cost of probate. And the reason for that is if we have a fully funded, properly designed revocable trust, then the estate administration, or what I would call trust administration, at the death of the decedent is going to be much more streamlined, generally speaking, than probate. Now, are there exceptions to the rule? And the answer is yes. I once had a wonderful lady who was a client. She moved to Maryland from New York. And when she moved here, she had, I would say, assets in 25 to 30 different institutions in New York, 25 or 30 different banks and institutions. And through the gallant efforts of her relatives, most of those assets were able to be consolidated and retitled, but not all of them were done by the time she died. So that means that there was a lot of extra cleaning up, there was a lot of extra maintenance, there was a lot of extra running around and administration. But the idea would have been to, get all of those assets fully funded, fully aligned in the revocable trust, and then the administration would have been much, much more streamlined. Now, a revocable trust structure looks like something like this. So we see that here the revocable trust has taken over. The revocable trust has become the driving force of the estate plan. And remember, we need those two steps. We need the implementation of the trust, and we also need the full funding and alignment of the trust assets. Plus, we need to verify all beneficiary designations. For those of you who have businesses or business interests, you'll notice the arrow here pointing to assignments. Your business interest would either be transferable on death to the trust or it would be assigned. Some of you have LLCs. Those LLC interests would be assigned to the trust so that there's no probate there. Some of you may look at this and say, well, gosh, Steve, there's still a will there. Well, you'll notice that the will has now become secondary to the trust. And for those people who unfortunately may not have all the assets titled in the trust the way they're supposed to, the will in a revocable trust plan stands in reserve to the trust as a backup document. So in a perfectly executed revocable trust where you're being intentional and we are being intentional with you, we're going to have a fully funded, fully integrated revocable trust, and then there's no probate at death, and our plan has worked the way that it's supposed to work. Now, we've talked about wills versus trust, which is really the conversation of probate versus non-probate. And as we head through the midsection of our presentation this morning, I want to now talk about the third category of assets. And if I could, I would just, use my hands here this morning to kind of illustrate three categories. I would like you to think in terms of wills. And then on this side of the page, I would like you to think of the third category. So with first category would be wills. The third category would be revocable trust, which we just discussed, meaning probate versus non-probate. But in the middle, I would like you to think of another category, and that is what I would call non-probate transfers. So a will by its very nature goes through probate. The revocable trust, properly done, by its very nature has no probate, but we also can avoid probate through non-probate devices or transfers. And many of you are familiar with these. Joint ownership. If I die with a jointly owned asset, it's going to go to the surviving joint owner. Most of us really understand that. Beneficiary designations. If I die with a proper beneficiary designation, there's no probate. Life estate deeds. Many of you have heard of this, but some of you may not. It's possible to title, in Maryland at least, it's possible to title a piece of property, a real piece of real estate, where you have a life interest in the property, and you either retain the power to sell it or you don't. And if you don't retain the power to sell it, that is actually a Medicaid planning device, but we'll talk about that a little bit more. But this avoids probate. It's a wonderful tool in the right situation. It's very simple. It doesn't provide for a lot of flexibility, but at the death of the person, it provides for a cost basis adjustment at death, a step up in basis. It also provides for avoidance of probate. Transfer on death. Many of you have these types of accounts through your financial advisors who recommend these things. So there's nothing wrong with this. This means that upon your death, the brokerage type account goes directly to the beneficiary. Payable on death, this is a bank beneficiary designation. The payable on death account goes to the beneficiary. And then in some of the northeastern states, we've seen things called the in trust for account, which is very similar to a POD or TOD account. Now, the problem with these types of transfers is that they don't allow for control. In other words, if I am a joint owner, or if I have a beneficiary designation, or if I have a transfer on death designation, it's definitely going to go to the surviving beneficiary or the surviving joint owner. The problem is that maybe I had other intentions. Maybe I had an intention that this particular asset was to go into further trust for my spouse, or further trust for my child or grandchild, or niece or nephew, or I had a special needs child and I needed that money to go into trust for that particular person. So there are lots of reasons why these types of transfers can be used, but most people don't use them. They use them only for special purposes. For example, we might want a particular asset in an elder law situation to go by transferable on death to a certain place. We might want the asset to go from here to here by using some of these designations. But very few people, once they're properly educated, would rely on these transfers as the sole estate plan. Now let's talk a little bit more about non-probate transfers. When we talk about estate plans actually working the way they're supposed to work, we're really talking about not only the documents. Remember, we talked about this. We're not only talking about continuing education and updating, but we're talking about something also very important called the funding and alignment, which we talked about. And I would go one step further with funding and alignment, and I would actually say, not only making sure that things are titled properly, but what are we really saying? We're making sure about how assets are flowing. So one of the most important things in estate planning is not only the funding and alignment, meaning getting things where they're supposed to be as far as assets, where they're supposed to be and flowing the right way. But that's the point, is that assets have to flow in the right way. This is a better illustration here. Let's say that I had the greatest will or the greatest trust in the world. I had spent a lot of time being intentional. I had the best counseling in the world. I had the best documents in the world. I was quite convinced of all that. But now I pass away. And in my documents, I wanted certain things to happen. I wanted my will or trust to direct assets to go this way or that way. And if the person who I left the assets to was deceased, God forbid, I then have contingency plans, and the assets are going to go this way, or they're going to be held in further trust for the protection of grandchildren, or whatever the goal may be. But see, if I look at this slide here, I just realized in hindsight, unfortunately, that look at how I had these assets transferred. I actually had these assets titled in a way that actually would bypass my will or trust. So my point is that TOD and POD and beneficiary designations and life estate deeds have their place. They are usable and they are sometimes very powerful in their use. But if we don't have the assets properly aligned, then what can happen is our estate plan can fail. My assistant Mary and I were meeting this morning, and we were reviewing an estate plan, and we were actually looking at the assets the person had, and we actually looked at the way they wanted those assets to flow through their revocable trust. And by looking at this and by comparing the non-retirement assets to the retirement assets this person had or has, we are looking at that and we are saying this is not going to work. This person does not have enough of these type of assets to make what she wants to do work versus the retirement assets that she has, and those assets are going a different direction. So not only the documents are very important, but how the assets flow is critical to the success of the estate plan. All right, Jeff, I think we're about halfway through the presentation. I wanted to stop and see if there's any questions at this point.
Thank you, Steve. We do have a question. We have the first one here being, to confirm, an IRA should list beneficiary as individuals and not as a revocable trust, but bank accounts should be in revocable trust.
Well, thank you for that question, and that's a great question. I'm going to answer that in two different ways, hopefully. Bank accounts generally should be, if you have a revocable trust, and by the way, each individual person's situation is different, as you know, but if you have savings, checking, money market at a bank, those really should be in your revocable trust, generally speaking, unless you have a specific reason they should not be in the trust. The reason is we're using the revocable trust 9 times out of 10. We're using that as a funnel. We're funneling assets down to the beneficiaries, and we're trying to make sure that everything avoids probate. So generally speaking, yes, all of those things should be there in the trust if we're going to use a revocable trust. Now, if you have a beneficiary designation to make, excuse me, and we need to choose between who is going to receive this retirement plan. So it could be the individual beneficiary. It can be a trust, meaning a revocable trust itself, like you described. Here's my revocable trust, and I'm going to leave my beneficiary designation as the revocable trust. Or you might be leaving a trust for someone, meaning there's a revocable trust that establishes a further trust for a beneficiary. So the actual beneficiary could be the trust that is created for the beneficiary, not the revocable trust. So I've mentioned 3 things here, actually not 2. The individual as beneficiary, the revocable trust as beneficiary, and the subtrust or the subtrust, meaning the trust created for the individual as the beneficiary. Many times in our practice, we make the subtrust the beneficiary, but each plan is different. And we see many times that estate planners will make the revocable trust the beneficiary itself. And the revocable trust, if it's drafted properly, can do that. But there are pros and cons, in my opinion, to using the revocable trust as the beneficiary. So I hope that helps, but this is going to be a fact-specific thing based on your circumstances.
Thank you, Steve. And another question, will you be talking about the executor's role in the revocable trust?
Thank you. Well, yes, I wasn't going to do that, but I'm going to back up now and just talk about that for a second. Let's go back to the revocable trust. And I think this is a great question, so thank you. 9 times out of 10, or maybe 100% of the time, the executor or the personal representative in Maryland of the will and the trustee of the trust are going to be the same person. This is going to be the same person. So let's say we have a fully funded revocable trust and you die. Well, your trustee is going to administer the trust and hopefully will not have to open an estate at all as personal representative. So depending on whether you're single or married will depend on whether the personal representative actually has a role. So for example, if you're married, the personal representative would be the person who is going to make the certain tax elections, for example, portability, or the marital trust election called the Q-tip election. So it depends on whether you're single or married. If you're single, and we're just trying to keep this simple, there may be no role at all for the personal representative because maybe there's no estate to open, or maybe someone has passed away with a very small asset, like a used vehicle that's worth $7,000, and now the personal representative needs to open a small estate, an estate of less than $50,000. So I would say with a trust, our goal is for the personal representative to really never have a role unless it's for tax elections after death. But if there are small probate assets that crept in somehow, a small car that was left out of the trust or whatever may be the case, the personal representative may have something to do there with administering the estate. And hopefully it's a small estate. And if it is a small estate, all we have to do is really negotiate the sale of that vehicle, for example, and then the pour over occurs, meaning that $7,000 now gets dumped back into the revocable trust. If there is a revocable trust situation and an executor is having to get involved because there is a regular estate, an estate for a single person that's more than $50,000, now we know we've really had a plan that did not work the way it was supposed to, because now the executor is going to have to administer a regular estate and the revocable trust estate, and that's not what we want. So what we're trying to do is minimize the role of a personal representative. That's a great question.
Okay, thank you, Steve. And another one here from our new clients, Wadi is actually on the call. And probably going back a little bit to one of our previous slides. And the question is, how about a brokerage account? Can we put some in APT and RLT? I think it's referring to revocable living trust. Maybe trying to ask for a little bit of context to the question, but does that make sense to you, Steve?
Well, thank you and welcome, Wadi. If I understand what you're saying, I think I'm going to try to intuit what you're saying, and that is it necessary to put 100% in a revocable trust? And the answer is no. So revocable
Steve, the APT refers to asset protection trust.
Oh, I see. Okay, so if we're using an asset protection trust of some kind, we are usually looking at how much to put in that particular trust and how much to leave out. So remember that assets can be held in a trust, whether it's an asset protection trust or not, but the assets that we don't want to be driven by that trust can be held in a different way. And at the time of death, they can be driven by transferable on death. They can be held in a revocable trust and driven a different way to the beneficiaries. So the answer is, if you have an asset protection trust that you're implementing or have implemented, it's not necessary for 100% of the assets to be in there. And as a matter of fact, if it's a Medicaid trust, generally speaking, we don't want 100% of the assets to be in there because we don't want the grantor of the trust to be completely not without assets and not being able to control at least some of their own money. I hope that got close to your question.
Thanks, Stephen. One more question, then we'll move on.
And then we'll need to move on, Jeff.
Yes, so the difference between a revocable trust and a non-revocable or irrevocable trust.
Thank you for that question. So here's how over the years I have kind of, settled in on answering that question. A revocable trust is merely a substitute for a will. I can have a will or I can have a trust. And if I have a trust, what am I choosing? I'm choosing privacy. I'm choosing avoiding probate not only in Maryland, but in other states if I have another property. I'm choosing that I want a private agreement that I can create myself. And I'm also choosing to avoid the register of wills. So a revocable trust is really just an alternative estate plan rather than having a will. An irrevocable trust, in my opinion, they come in different varieties. First of all, we have lifetime irrevocable trusts. These are trusts, I would say, are for a special purpose. So I would like you to think in terms of irrevocable trusts or trusts with a special purpose. I'll give you some examples. A life insurance trust, a charitable trust, a special needs trust can be irrevocable, okay? A residence trust. So there are various types of trusts. Those are just a few examples of lifetime trusts. A gifting trust, for example. I want to give gifts to someone during my lifetime, but I want them to be held in trust. So those are all trusts with a special purpose. Now, the alternative to that, or the other type of irrevocable trust, is the trust at death. So let's say I have a revocable trust, but at my death, I'm leaving a trust for my surviving spouse. So that is a trust established at death. In wills, we call that a testamentary trust, a trust that is established at death. With revocable trusts, we don't usually use the term testamentary, but I like to think of it that way, that if I have a revocable trust or a will, and I'm leaving trusts at my death, those trusts are also irrevocable. So irrevocable trusts at death, irrevocable trusts during life. We generally cannot change a trust that's established during life that's irrevocable, but there are some ways of doing that nowadays. There are ways of changing an otherwise irrevocable trust. At death, there are still some ways of changing an irrevocable trust, but generally speaking, it's a little bit harder. But a revocable trust, we can change that at any time. I hope that helps. All
Thank
right,
you,
Jeff,
Steve.
I'm going to move on now, just in the interest of time. We're a little bit closer to 12 o'clock. We're about 5 minutes behind, so I'm going to speed up a little bit. Now, equally important, as I mentioned at the beginning of the presentation, is not only planning for what happens at death, but planning for what happens during life. Powers of attorney and advance directives. So we want powers of attorney, which are the financial instruments. And you'll notice here, Maryland has its own statutory power of attorney since 2010. This is very, very good for clients, in my opinion, but it doesn't cover everything, and it doesn't give clients the flexibility that they really need during life, especially for elder care matters. So we layer this many times. Many advanced estate planning attorneys will layer the power of attorney for the statutory form as being one that is used for simple matters, and a general durable power of attorney for more complex issues. Remember that a power of attorney controls all assets in a will plan, and in a trust, meaning a revocable trust plan, the powers of attorney control the assets that are outside of the trust. So the power of attorney controls the retirement plan assets and life insurance in a revocable trust plan, but the trustee of the trust controls the other assets that are inside of a revocable trust. So powers of attorney are arguably the most important of all the estate planning documents, arguably. Very, very important to design those, to understand them, to understand the scope of the power, to understand when the agent's power goes into effect. All of these things are counseling issues. Elville and Associates, I'm proud to say, is the only firm I'm aware of in Maryland, or at least one of the only ones, that actually spends concentrated time on the design of powers of attorney and advance directives. On the advance directive side, what are we doing? We're naming our agents for healthcare, very important. We're deciding when those agents' power goes into effect. We're waiving HIPAA, the HIPAA laws that protect our medical records. We are making end-of-life decisions in advance. We're doing organ donation designations or not. We are deciding about donating our bodies or not to science and various colleges and universities for study or not. And we're making plans for final arrangements. Very, very important things. We have clients today living long, long lives. We've had many people live over 100 years of age. These documents are essential for a very strong estate plan. Now, notice here as we try to move quickly, the purpose of these plans, of these documents, is not only to facilitate your decision making and to take care of you, but to avoid guardianship. We are avoiding adult guardianship. And on the financial side, there is no substitute for guardianship. We either have an agent or we don't. And we are very much possibly subject to guardianship of our property. On the healthcare side, the law is a little bit more flexible, and there can be a surrogate decision maker. So on the healthcare side, we have a little bit more flexibility to avoid guardianship of the person. But the whole thrust here is to take care of you. And on the financial side, many people don't realize that the thrust of a financial power of attorney is to not only take care of you, pay your bills, take care of your needs, but also to take care of your spouse and any person who may be dependent on you. So the financial power of attorney, incredibly important. Now, in the interest of time, I'm not going to go through every one of these slides, but the Maryland statutory power of attorney is simply not enough powers for people who are doing full-fledged estate planning. Remember the purpose of the Maryland statutory power of attorney, which is the first one here as we look at this PowerPoint. The purpose of this was to really shore up the power of attorney laws in Maryland in 2010, which were in desperate need of help. There was a lot of fraud and abuse in the world of powers of attorney in Maryland. So now the statutory power of attorney, like DC, New York, Delaware now, West Virginia, the statutory power gives your agent the assurance, gives you the assurance that your power of attorney is enforceable. It will be enforced if it needs to be by your agent, and it has the force of the law behind it. It will actually work the way it's supposed to. But the statutory power of attorney was really designed, in my opinion, for the average person. So think about what we said at the very beginning of this presentation. Does the average person have estate planning? And the answer is no. It's only the above average person, if you want to think of it that way, as silly as that may sound, that has estate planning. So if we are not talking about the basics here, then we need more powers than just the statutory form. So we highly recommend that powers of attorney be designed, that they be crafted, that the general durable power of attorney be customized, just like trust powers and a revocable trust would be customized. But my point here is that the Maryland statutory power of attorney has its place, and hopefully it will never be needed, or if it is needed, it will suffice. But just in case that the powers that are contained in that statutory form are not enough, which they probably are not, then we need to understand why that is. So the following slides really get into details, which I won't, in the interest of time, go through. But in your materials, as you use this as a resource, you'll see that the Maryland power of attorney, when you're doing real estate planning, we need to enhance these powers. And the way we do that is through the use of a secondary general durable power of attorney. And when you go through all of these powers, you'll get a real idea fairly quickly of just how simple the Maryland statutory short form is. Now, there is, in full disclosure, a long form. So Maryland has a short form power of attorney, statutory form, and they have a long form. The long form is actually quite comprehensive, but there's not a lot of flexibility in these forms. We are not allowed, in our view, to change these forms very much. So the general consensus among advanced estate planning attorneys is to use the basic Maryland power of attorney, as you see here in this slide, but to layer it with a general durable power of attorney that can be customized. So I hope that makes sense. These slides here are to really give you the information you need to understand that the simple Maryland power of attorney is not enough. Now, the advanced medical directive, we want to encourage you to customize this form. There are many different types of advanced directives, not just one. We use the Maryland Attorney General's form. There are other forms like the 5 wishes, which many of you have seen. A very nice client came in the other night and was very kind to give us a sample of the Catholic faith's form that many of you have seen. We recommend the Attorney General's form unless you want to use a different one, because it's highly customizable. And when you have a chance to sit and look at these things here, personal preferences, all of your particular communications that you want people to know, all your personal preferences about where you would want to live if you were incapacitated, the foods that you would want to eat, the particular instructions that you have, we strongly encourage you to think about customizing this form. Why? Because for some clients, this is the most important form. And remember that it's all that your relatives will know about what you really want is what you've set forth in writing, because other than what you've told them verbally during your lifetime, they won't really understand or know what your full wishes are. So we strongly encourage you to customize your advanced medical directive. The MOLST, which is the medical order for life-sustaining treatment, this is required in Maryland. For those of you who have never heard about this, it takes a little bit more time to explain this, which is above and beyond the scope of our discussion today. But we believe here at the firm that a good estate planning discussion about incapacity will also include a basic discussion about MOLST. And you can read more about this on the Maryland Attorney General's website, marylandattorneygeneral.gov. For those of you who are interested in MOLST and you would like to get more information, Jeff and I can send you some of the basic information that is on the Attorney General's website. We're happy to email that to you, but it's something for you to be educated about. It's something for your agents and your spouse and other agents to be definitely educated about, to understand that Maryland is only one of a handful of states that actually requires this. Many states call this POLST, a provider or physician's order for life-sustaining treatment, POLST. So this is something, if you've never heard of MOLST, I strongly encourage you to educate yourself about it. And if you would like more counseling, we at the firm here will educate you. Now, Jeff, in the interest of time, I'm going to keep right on going. We're a little bit after 12 o'clock. I'm going to now switch gears and talk about estate planning, and not only that, but estate tax planning. So the current state of our tax environment is that we've all been really hurried up. We're hurrying up but waiting. So hurry up and wait. Many of you have been watching for the last year or more about the congressional actions about potential tax changes in the laws. Well, those largely have not happened. The taking away of the step up in basis that was threatened, the lowering of the estate tax exemptions has not happened, as was predicted before the end of this year. Now, of course, we're still not at the end of the year, but it doesn't look like it's going to happen. And many other onerous tax laws that were going to be changed have not happened. Although some tax laws have changed that have to do with the very wealthy that were included in the infrastructure bill that was recently passed. So largely, we have not experienced any of the major tax changes, but let me go through these bullet points quickly, and I'll give you an idea of the current environment. So our current environment is we still have the step up in basis, thank goodness. That means on our deaths, non-retirement assets will get a cost basis adjustment, generally speaking, to fair market value. So that's very, very good that has not gone away. Our exemption amounts on the federal level are $11.7 million per person to avoid estate tax and gift tax. That amount is supposed to go up to about $12.6 million based on the high cost of living index or inflation number recently. Maryland's estate tax exemption is still at $5 million, so this is definitely a surprise to many of us that thought these exemption amounts would already have come down. The use of portability, which is the ability of a surviving spouse to be able to simplify estate tax planning, that has not been in flux, that has not been in question, and we're very, very happy that portability looks like it's here to stay. For those of you who are not familiar with what portability is the ability of a surviving spouse to use his or her deceased spouse's exemption amount. So a surviving spouse would be able to use the $11.7 million currently, the $11.7 million exemption of his or her deceased spouse, plus their own exemption, and to be able to do it relatively easily compared to the way the laws used to be. So portability is a great thing, and we don't see anything coming down the pike that would change portability as far as we can tell. The issues for many spouses are, will we control assets upon the death of one of us for our surviving spouse for remarriage protection or asset protection? So one of the things I want to point out is about a year ago or a year and 3 months ago, the new law, the new spousal elective share law came into place. So as we think about marital control or asset protection, one of the things that's in the law right now that's not necessarily a tax issue, but it's a marital control issue or marriage issue. For those of you who are single, I apologize, I'm digressing for just a second here. We need to be aware that the new law provides that our surviving spouses are entitled to at least 1/3 of all assets. And it's a formulaic thing. It's not exactly 1/3, but it is designed to protect surviving spouses. So we need to understand this. And if we're trying to do planning that's going to make sure that assets flow down to our children and grandchildren and nieces and nephews and so forth, we want to make sure we understand how to protect ourselves with prenuptial agreements and other agreements that may need to be in place, even postnuptial agreements, so that a new spouse cannot get 1/3 of our estate if we have not planned properly. Now, in the elder care aspect or elder care world, the costs of care continue to rise. What is the difference between estate planning and elder care planning? Well, in a nutshell, conventional estate planning is everything we've talked about so far. Minimizing taxes, achieving our goals, leaving assets to the people we want, and protecting those assets if we want to, or simplifying the process if we want to, understanding how assets flow. All of those things comprise estate planning in the traditional sense, including incapacity planning. That's a very big issue. But in elder care, and this is not as confusing as it may sound, we're simply shifting gears. We're simply shifting our focus away from some of those traditional things to more of asset protection for long-term care, a focus on how we're going to pay for the cost of care, Social Security issues, housing issues, special needs issues, all of those things that can be done under federal law to protect assets and protect people. So asset preservation is a huge issue in elder care planning and Medicaid planning. Flexibility is a huge issue, not only in conventional estate planning, but in elder care. Flexibility is one of the most important things that we can build in if it's appropriate. Flexibility is not always appropriate. Massive amounts of flexibility may not be suitable, but generally speaking, the more flexibility we can build in, the more circumstances can be addressed in the future, and we're all covered. All of our bases are covered. I met with a client this morning who had done good planning, and this person's planning now is going to be able to be accomplished despite changing circumstances because of the flexibility that we have in those documents. In elder care, we're asking ourselves many questions, but we're asking ourselves, should we divest assets? Should we change the ownership of assets between spouses? Should we give away assets to trusts, or should we give assets away to individuals, either for veterans benefit planning or Medicaid planning? And if we can do that and still retain some control, if we can have the best of all worlds, if we can maintain at least a little bit of control of those assets, is that advisable? All of these kinds of things, housing, nursing homes, assisted living, all of these types of things are all comprising the world of elder law and elder care. Maryland remains one of the worst states in the country, I'm sorry to say, for paying for individuals to stay at home and be cared for, or paying for individuals to be in assisted living and having the cost of care paid for. So we're not very proud of that, and we're trying to change that. But Maryland is still quite liberal for long-term care planning in general, for skilled nursing. And so a lot of elder care consultations are going to revolve around the world of Medicaid and what we do to preserve assets and to plan around the preservation of assets with regard to the world of Medicaid being kind of the umbrella that pays about 86% of all long-term care. even though Maryland is one of the poorest states with regard to taking care of its citizens with regard to in-home care or assisted living, which is generally private pay in Maryland. Jeff, I'm going to stop and then we'll go about another 10 minutes talking about asset protection.
Thanks, Steve. No other questions at this time.
Thank you, everyone, for your patience as we've gotten through this particular portion. And I've been particularly methodical in this presentation, so hopefully it hasn't dragged out too long. And we have about another 10 minutes and we'll take a break finally for final questions. So as we talked about, we talked about estate planning, we've talked about elder care planning, elder law, and now I want to talk about asset protection, but I want to break this out into 3 different categories. There is lifetime asset protection. This is the asset protection we enjoy today. You and I may enjoy a certain amount of it, and you may not be aware of it. And hopefully you are aware that you have some lifetime asset protection. Long-term care asset protection, just what we were talking about a minute ago. Medicaid planning, elder care planning. How do we preserve money from the long-term care drawdown of our funds if we can? Asset protection at death. We talked earlier about the difference between irrevocable trusts at death and irrevocable trusts during life. Well, here we're talking about asset protection at death. So without further ado, let's get into lifetime asset protection. Now, this is just something that I want to make you aware of because it's so important. No matter what your goals are, no matter what your emphasis is, whatever your needs are, this is something you need to be aware of. Unfortunately, now you're going to see that for married people enjoy more opportunity for asset protection in the general sense than single people. So let's talk about this. Tenants by the entirety. If you're married on this call, 9 times out of 10, 99% of the time, you're going to own your residence as tenants by the entireties. That means that you have an undividable whole in your residence or any other real estate. Maryland is a huge tenants by the entirety state, and so is Delaware. This means if one of you spouses gets sued and there's a judgment against one of you, you cannot lose your home. Now, one of the things I want to throw out here quickly is that if you're married and you have non-retirement assets, almost any non-retirement asset can, like a brokerage account, can be titled as tenants by the entireties. So we want to go away from this webinar this morning and look at brokerage accounts and say to ourselves, should we have these titled as husband and wife? And Maryland has a wonderful law that says if you have tenants by the entireties as the titling of any non-retirement asset, and then those assets are transferred to a revocable trust, you retain the asset protection. So this is a very important thing that most people are not aware of. Most financial advisors are not aware of it and have not implemented this for their clients. Now, moving on, life insurance is protected from the claims of creditors, both the death benefit and the cash value, if the spouse or child of the person is the beneficiary. Annuities are the same way. So far, hopefully you've seen there's 3 possibilities here for asset protection already that you may not have been aware of. Qualified plans like 401ks, 403bs, 457 plans, plus IRAs. These are protected from the claims of creditors. Inherited IRAs are not. The IRAs that we leave to our children, grandchildren, nieces and nephews and so forth, those are not protected from creditors, and therefore if we want to make sure those IRAs are protected, we have to leave those in what we call an IRA trust or a further trust at death. In the interest of time, I'm going to move on now to Medicaid or long-term care asset protection. So the use of asset protection trusts, such as a Medicaid trust, a Medicaid asset protection trust is possibly the most versatile, powerful, domestic asset protection tool that has ever been developed by the elder law bar. This is like the Swiss Army knife of asset protection. It's a trust that allows the grantor of the trust to start the Medicaid 5-year period, meaning the 5-year look forward period to divest assets, but also to retain an element of control and planning. So the Medicaid Asset Protection Trust is a very powerful tool. For certain veterans, Veteran Asset Protection Trust is a very powerful tool as well that can help the veteran solidify asset protection for not only Medicaid, but for VA benefits. In 2018, the VA tightened up its rules about veterans benefits, and one of the major pensions, which is called the aid and attendance benefit. So we want to make sure that veterans have access to this kind of planning. Use of trusts under wills. We don't have time to go into all the details of this, but if we're dealing with a situation, or you're dealing with a situation with a spouse that has diminished capacity through dementia or some other illness or diminished situation, we can use trusts that are established under wills to preserve assets. This is a wonderful strategy for many, many couples. The augmented estate. In a nutshell, what this means is that about a year ago, Maryland passed a law that finally recognized that if there is a will that provides for a disabled spouse, meaning a trust under a will, that the state of Maryland, as long as a sufficient amount of money was left to that trust at the death of one spouse's passing, and the surviving spouse, which is the disabled spouse, has the benefit of at least a certain amount of money, the state of Maryland would waive its right of recovery. So this was something that was routinely avoided in the past through planning, but Maryland has finally recognized this. So this is a huge issue for couples where one of them is not well, and there's Medicaid planning for that couple. The 5-year look back period, or what we would call the look forward period, this is something that a basic understanding of this is hugely important for people who want to do Medicaid asset protection. So we usually do this in the form of a counseling session called an elder law consultation. The rule of halves is the concept that even if there is a single person who's never done any Medicaid planning, that whatever assets they own, and these are non-retirement assets we're talking about usually, and they have to go into a nursing home unexpectedly, that we can preserve under the current law about 50% of those assets. So the rule of halves is crucial to be thinking about when it comes to elder care planning. Life estate deeds, this is a way to start the 5 years. If someone wants to keep it very simple, we can preserve real estate by starting the 5-year period by using a life estate deed. I want to throw out that there are other elder care strategies that we don't have a chance to go into today, such as the purchase of a life estate in a residence. So let's say that you have an elderly loved one who you would like to preserve some of their assets, but they're actually going to come live with you. There are strategies under the Deficit Reduction Act of 2006 that actually allows this person, under certain circumstances, to purchase a life estate interest in your home if they're going to live with you. And there is a very shortened period for a look back period, only 1 year instead of 5. And there are other strategies like this. So I just want you to know that this is a robust area of the law where there's a lot of things that can be done to preserve assets. And lastly, asset protection at death. We've talked about asset protection during life, asset protection for Medicaid or long-term care purposes, just to think about those things in different ways, and now asset protection at death. So we talked about earlier when a very nice person asked a question about trust during life or trust at death. Here we're talking about generally trusts at death. These are trusts that are established for spouses, such as a marital trust or what we might call a bypass trust today, a trust for a child or grandchild. Here at Elville & Associates, we call those kinds of trusts legacy trusts, although it's just a term of art. The trust is basically this. A trust at death for a beneficiary is basically what we would call an irrevocable spendthrift trust. This is a trust that is protected by a spendthrift provision that the beneficiary can't give away the assets of the trust. The beneficiary could be in control of those assets. Maryland law says that they can be, but there are pros and cons to this, and we need to have both eyes open about beneficiary control of their own trust. A lot of the counseling that goes into this has to do with structuring trustees, structuring a special fiduciary that Maryland authorizes now called a trust protector. It's actually officially called a trust advisor in Maryland. Understanding powers of appointment. What can the beneficiary do at the time of their death? Can they give it to other people like spouses? Or no, does it only go to my descendants? Can they give it to charity? All of these are counseling issues. And then, of course, special needs beneficiaries. A trust can be left at death for the benefit of a special needs loved one, or a special needs trust can actually be created during life. So I want you to go away from this particular segment of the discussion understanding that asset protection is not just one broad concept. It really is specific to what kind of asset protection are we trying to do? Is it during life? Is it at death? Is it Medicaid related? Or is it just generally speaking, what kind of asset protection do I have as I live my life? My IRAs, my 401ks, and other types of life insurance and annuities. And for you people who are married on the call, remember, tenants by the entirety's protection, very, very, very important. Now, the Secure Act, as we start to wrap up, is something that is affecting a lot of people. It affects most people who have retirement plan assets. Not all, but it affects most. It was signed into law by President Trump in December of 2019, became law January 1st, 2020, and it ends the stretching out of IRAs. So we just want to make sure we cover this at the end of our presentation here. Pretty much all estate plans need to be reviewed. Clients need to be educated about how does the Secure Act affect the distribution of retirement plan assets. And the reason is there's only about 5 exemptions. There's only about 5 exceptions. And generally what this means is that the vast majority of healthy individuals, meaning healthy individuals being the vast majority of people, those people who are healthy and well, they're not disabled, they're not chronically ill and so forth, those people are going to be affected by the Secure Act, which means that when you leave retirement plan assets to children or others, they are going to be subject to a 10-year distribution of the retirement plan asset, or in other words, the great acceleration of taxation on those assets unless they are already Roth assets. So we need to discuss this with most clients or prospective clients, understand how to deal with the Secure Act, and really talk about your goals and whether dealing with this is something that's important to you. But there are some strategies. It definitely will affect most estate plans. We just want to make sure that we're covering this. So as we end up, and we are going to end on time, we talked about all of these things. We've talked about all of the education, all of the processes. We've talked about the difference between traditional estate planning and what we would call caring for clients or legacy process-oriented planning. And we're strongly recommending the latter. We're strongly recommending that you engage in a process with a firm that provides a process. Jeff talked about our client care program and our other counseling processes. We encourage you to set a consultation. We want to make sure you're not only educated, but we want to encourage you to move forward. We want you to complete an estate planning questionnaire. Many people are concerned about this, meeting a new person and engaging in these kinds of personal discussions. So the assurance that I want to give you is that there's nothing to fear. Here at Elville and Associates in our main office here and our other locations, we have confidential conference rooms that are completely private. We talk to you and advise on a very broad level. We do not have expedited or quick discussions. We want to give you the time to think. We want to give you a place where you can actually relax and be able to consider the major things that we would bring up in the process. So there's nothing to fear. We want you to complete a questionnaire, which really gives us the information that we need. We want you to bring your current estate planning documents. If you have existing estate planning documents, we want you to bring those so that we can review them. We do not charge to review existing estate planning documents. We want you to have an advisory team. If you have a financial advisor and CPA already, we would love to meet them and collaborate with them. If you do not have a planning team or an advisory team, we would like to help you form one. We would like you to take the time to pose any questions that you have in advance. We love it when clients come in, they have lists of questions that they want to go over. You do not have to do that. But we think as a preparation for the meeting, if you feel inclined to write out a list of questions, it helps us, and I think it would help you to know that your questions are being answered. And as I mentioned, our main goal is that we want to give you a path forward, but we want to give you time to think. Jeff and I have been doing this a long time together, and we've noticed over the years that, especially with COVID-19, our lives are just so much more complicated, so much busier, the pace of change is just so great prior to and after COVID-19. We want to give you time to really think, relax, and just have a place where these major considerations about life can be discussed. What is important to you and what your goals are. So that's what we want to do, and we hope that you've enjoyed today, that you'll use this as a reference tool, that you'll come back and see us again on these webinars, and that you'll feel free to contact Jeff or me or my assistant Mary Gay Kramer at Elville and Associates, and understand that we want to make this process as easy for you as possible. We know it's not easy. Jeff, with all that said, I'm going to turn it back over to you.
Well, thank you very much, Steve. And the process isn't easy. You made that look very easy, though. I will say that.
Thank you, Jeff.
So, a very job well done, as always. So, and a lot of comments as far as a great presentation offered by you this morning, I should say, and afternoon. So now would be your time to get those questions in that are in your mind, and I know that you have some. But as you get those last questions in, I'll say that I'll be sending some things out to you. I'll be sending today's video. I'll send the slides out to you again. The MOLST packet that Steve referenced, I'll be sending that out to you. A link to our events calendar. We are going to take a little bit of a break after Wednesday's presentation, but we are going to come back strong in January, and I have our entire presentation calendar up through the end of March, and we're still going to be adding some more. So I want you to take a look at that. And also, I'm going to be sending you articles that Steve wrote about the Secure Act, which is a very important topic of discussion that Steve is very well informed on. So I'll send you the articles that he wrote about that as well. Also, as far as our Elville webinar series goes, Wednesday at 10 o'clock, we have Steve talking about legacy and charitable giving and philanthropy, a topic that many of you have been asking for a long time, and it is finally here on Wednesday, December 15th at 10 o'clock. And then we'll take a little break. And then on January 7th, Friday, Steve will be talking about what families need to know about planning for a loved one with special needs, a good topic to start off the new year with. And then on the 11th of January, part 4 of our very popular Elville wellness series of our Elville webinar series, setting health goals for the new year. That is one that you certainly don't want to miss. And then certainly check out our events page on our calendar for all of the other webinars that we have coming up. And the last thing I would like to say is, as we round out the year here briefly, is I never thought as we came up with this Elville webinar series many months ago that it would take off as it has. And for that, we're very blessed here. We certainly cannot do it without you, our clients, our financial advisors, those interested in Elville and Associates. We've been privileged to educate thousands and thousands of people through our Elville webinar series over the past many months. And we're looking forward to 2022 and what that brings, new topics. Topics we'll certainly revisit that are of interest to you. And we're gonna maintain our mission, but bring some new things to you as well. So just wanna thank those clients for our confidence in Elville and Associates, to our financial advisors for your partnership, and for those still interested in Elville and Associates but have not yet become clients, we look forward to seeing you in the office when the time is right for you, and hopefully that'll be sometime soon. So with that being said, let's see if we have any questions. And I've enjoyed being the moderator of all these events. It's adds something to my day that I just enjoy, and it's allowed me to be connected to people that wouldn't have been connected to in without the Elville webinar series. So that's been really fun for me, and I enjoy it. It's a fun part of my job here at the firm, which I do many things of. So let's see here. Many thank yous. Let's see here. Number of people saying, Steve, they're going to be in touch with you to schedule something. So we'll be on the lookout for that. Thank you.
Thank you.
And looks like no further questions, just lots of thank yous. And let's see. Thank you for these webinars. Excellent presentation. I truly appreciate it. Education is the antidote to fear of these instruments. Interesting anecdote. So, and that's from Irene, who I've been talking to just recently. So yes, thank you, Irene. Look forward to seeing you in the office soon. So, okay, with that being said, have a wonderful day. Happy New Year, Merry Christmas, Happy Holidays, and thank you for your relationship with Elville & Associates. And we'll talk to you again very soon. Have a great day, everybody.
Thank you, everyone.